Good morning again. In this part 2, we are going to deal with the right to silence further issues. We said in the part 1, in 1975, the Australian Law Reform Commission report on criminal investigation handed down its reports. It is regarding the pre-trial right to silence. Law Reform Commission recommended the retention of the pre-trial right to silence for the following reasons. Number 1, Law Reform Commission said there are several reasons for silence which are consistent with innocence rather than guilt. Therefore, refusal to answer questions to police or law enforcement authorities is equivocal. Number 2, allowing a jury to draw inferences from a suspect's refusal to speak, thereby creating a risk of wrongful conviction. Most suspects are not strong, they are not intelligent, they are not articulate. Therefore, it is a risk. Third reason the law reform commission given is no empirical evidence to suggest that the exercise of the right to silence results in high acquittal rates for serious crimes. Therefore, it is not necessary. Number 4, the law reform commission said the people who ask or the people who advocate inferences should be drawn from the right to silence. When the accused exercise right to silence, we have to draw inference. They are asking us to go departure from the whole tradition of the British criminal justice system. Therefore, it is up to them to prove that they have a strong case. In the Commission's view, they have not proven their honors, not discharged their honors. Now let us see one important case in right to silence, that is pre-trial right to silence. In Petty and Maiden versus Queen, 1991, 173, CLR 95. This is a case, it's a murder case trial. In this case, Australia's highest court, the High Court of Australia, decided that no adverse inference could be drawn from the exercise of the pre-trial right to silence. In this case, the defendant advanced a defense during the trial, which he didn't mention to the police during the pre-trial. The prosecution argued, therefore, the defendant failed to mention the defense during the police investigation. Therefore, we should draw inferences from that. But the High Court rejected the prosecution's argument and said no inferences can be drawn from the silence. Now let us consider another case, which is at trial silence. In Wessentainer versus Queen, 1993, 178, CLR 217, at page 117, 2 years after Petty and Maiden case, the Australian High Court, revisited these issues in a different factual context. Let us consider this in our part 3 video. Thank you very much for listening. Have a nice day. Goodbye.